sentence again, life imprisonment, death sentence, whatever it is. That is what the judge will do. But a jury has to now come up and say the person is guilty or not guilty. Or someone is the judge is who should be. And they are not making that decision necessarily on rules of law. At best, they do so based on the facts available. If we are not a jury system, sometimes, example, the U.S. court, any journalist who goes to a U.S. court for defamation is likely to.
Honorable Kennedy, on Adyapong, any Anas case na a war court no. Update be aba every Honorable Kennedy on Adyapong, ne lawyer ho. Na yebekwa akuti Israel FM na ye interview no en wode eye ho information ni nyina wode ato abonten eye den na esi new update be na aba afa Anas ene eye honorable case no yenkuti lawyer no
dependent on the kind of argument that the person makes. The argument Anas made in the U.S. court act, he created the impression that in Ghana some people are above the law. Especially politicians. Right. This is a statement that will appeal to every single juror in the United States or any part of the Western world, whether it is true or not. Because I mean, we're all here when even President Trump was held before legal processes and all of that. Right. So before a jury, you have the chance to, you can even be manipulated and get away with it. Jurors are sentimental. It is all profile jurors who say, oh, we have neighbor, we Christian, we say, you know how to play with your arguments to get them to give you the kind of.
But George, and no dear, no yellow, obviously, some quarter. Because so be making an argument, but superior arguments in the beginning. I'm sure, sir. Adyapong nankasa etimide necessary in the book and said me will I'm going to pick the best lawyers, underline best lawyers.
Yeah.
I'm very sure say the best lawyers now Adyapong Jew Mudino. Omunim all those things say they are during the say net here. Say one kawasim ya yebe buetia. Because honestly, I'm saying this because the excitement in Nabano may not be necessary because of Adyapong. But there are not excitement ni be a to say anke Ghana ha kebe frustrated system na
ya tumwa mu semno ya kofuto semno sa senko tota yo kwan mi no e faso bu akai de kan ni pe dia otomo fo no fo ba tinase no fa Ghana mpa nchehye ya yo faso bu akai no buate and I say obefa abuafo na for mu jury na for so abobo na so say ye so jury na the more for one and matches on chair obo ekwan a obo fa so ehwehwe mfemu it is the evidence that to anima kwan be no fa so na church be mo chair obo and remember na e wo so e na also go the court adwendwe mu say na now, I show them to say, and there's a more from that show this Subiano, and also with this of Pepe. It was more from the idea will be now. As some of Canada's issue, U.S. court, no, or we use jury system, no, and no, more from the show, so movie, now, yeah, a more Casa, more, I know what their court, no, I the verdict, and not the Timor from him, Hoche. Na omu and omu de back. And so it's important to say the kisa distinction. Now we are say you in the decision bar and verdict bar and not conclusive enough. So jury no econo for ginger sample no ban you and some are caught in the my say na day from one in safety. I guess a court no fast assembly. Now, Bonibeka or Entano as a decision or a judgment of the court. Court may find adoption. Also, court may just ask them. No court man can say it seems so. Say, we in a year, Moya court at the Bible. In such matters, the court necessarily has to take the verdict and enter it as a decision of the court or a judgment of the court. Anything short of this via every judgment. It said, pay attention to some of the arguments I know on social media. What is that from Sakoko aside? The post of a lot of conversation. He was very specific, saying the jury in the SS court has awarded a verdict of 18 million against Kennedy Adyapong. One can say the court has awarded a judgment of. In some sense, I think that those distinctions are key. And there he has said, there is no judgment against Adyapong. Legally speaking, there is no judgment against him. Now, the U.S. laws say, we are awarded damages against you. We are both say, what can do this or can not? We can say, could change to get before. There is this legal principle I refer to remedy so. And what you say, your both have a quarter. And man of my point says, we did this as I can a bullet soon far. Who cannot catch a court and say, the idea to me so dear. I say, no, so I taboo, I can soon a jack. When the mother will blow, on such a moment. Court meet me, no one should share and say, no shine. The entire my US for this principle, never any say, no, your case in the normal system where you have a judge sitting on the case. The judge, he is guided by the rules of law, the facts, and all legal principles. But in a jury system, the jurors are not necessarily making their decision based on the rules of law or the specific provisions of law. For example, say if a judge will make an award against Obi for damages act. They make specific awards, for example, for the road traffic offense, causing harm to other road users and everything. And running saying a 20,000 penalty and a 100 penalty unit. Penalty is that could be a 12 cities. So he will multiply that by that. But a jury can make some decisions no matter how outrageous they are. And now, then we say, the whole jury system is built around the perception that jurors may afford every until they represent the larger society, until their feelings are that of the larger society. And sometimes they may go overboard kakra. So, for example, when judges begin come, they'll tell you, there was this case, I think it happened in Ashanti region, and we are 4 million and about a kubako. So it's a murder case. Facts mean that I say a murder case. Now, judge no any jury now call you money. The expectation is that they will come up with a guilty verdict. But the star witness in the case is Mammy. Mammy, the mountain family. And somehow, or catch a jury, they say, we say about time, we bay or condemn and when and the it is not that the boy has not committed murder, but the woman is appealing to the emotions of the jurors. And jury system, we say, oh, dear, you know how to appeal to the emotions of jurors. Oftentimes, you can have a decision going your way. It's my but now, the Baba Kun, the Kofi Ahon and the customer. If it's a matter before the judge will decide, the judge will go strictly according to what the law says. Section 29, Section 30, and then Omoka Famenda and sentence again, life imprisonment, death sentence, whatever it is. That is what the judge will do. But a jury has to now come up and say the person is guilty or not guilty. Or someone will have a decision judge is who should be. And they are not making that decision necessarily on rules of law. At best, they will do so based on the facts available. If we are not a jury system, sometimes, example, the U.S. court, any journalist who goes to a U.S. court for defamation is likely to win, dependent on the kind of arguments that the person makes. If the arguments made in the U.S. court, he created the impression that in Ghana, some people are above the law, especially politicians. This is a statement that will appeal appeal to every single juror in the United States or any part of the Western world, whether it is true or not. Because I mean, we all hear when even President Trump was held before legal processes and all of that.
Right.
So before a jury, you have the chance to, you can even be manipulative and get away with it. Jurors are sentimental. It is all profile jurors who say, oh, we have neighbor, we Christian, we say, you know how to play with your arguments to get them to give you the kind of.
But George, and no dear, more yellow, obviously, some quarter. You can't so be making an argument, but superior arguments in the beginning. I'm sure, sir. Adyapong Nankasa, it's me the necessity in the book and said, me, I'm going to pick the best lawyers, underline, best lawyers.
Yeah.
I'm very sure, sir, the best lawyers now, Adyapong Jew Mudino. Omunim all those things say they are during the say it. So one kawasimia, you be buetia. Because honestly, I'm saying this because the ama excitement in Nabano may not be necessary because of Adyapong. But there are excitement to me, Nibia, but quiet to say, Anke Ghana ha, my one showing Grana, say Nipanuka will be the man now, would differ, now problem. And a case study could be, Yamfani say, you can JB Dankwa MP. Look how many years in ye, Yentiminya, but then the Anka Buchina. Kieti na answer when you say we differ and I say we did them. We be between the national court or ha. Me are frustrating a victim pay. You be frustrating a fino. Say nyakana you bet you. Is it not something that Emma yes at least your court system no? We need to work on that.
No, I think that comparison is a wrong one. First and foremost, don't in fact a jury case and compare a street case. Where it is an indictment proceeding, a wrong comparison. The motives are very, very different. I have to say, say, will be a percent of compare a radio show host by his ability to write. It's not necessarily the thing. Now, the kind of, and the example you made, the JB Danko example, let's even stick with that example. It is a murder case. Doing a murder case in Ghana, doing a murder case in US, there are things that would help you. But generally, there are some principles that would guide you. Every murder case, there are two ways of assessing it. We call the preponderance of probability and a balance of probability. So, you are putting things together to suggest that there is a likelihood something happened, or there is a likelihood that something did not happen. So you can say, oh, but you are quite to say murder. It comes under what you call proof beyond reasonable doubt. And also, if you share evidence, so you cannot compare these two situations. Now, you get back to even the jury process. Now, I mentioned earlier, the judge or the court instructs the jury on exactly what to do. If the jury in any way deviates from that specific instruction, it becomes a ground for mistrial, which is one of the contending issues before the court now. Now, court, Emma, jury, and a human answer, say, first and foremost, the jury was supposed to decide, say, Adyapong, for a guilty and or not guilty of the issues that have been brought before the court. Now, the second thing that the jury was supposed to do is, so one will say, or a guilty, then we should assess actual damage. Actual damages are in German. Beyond that, you should also assess defamatory damages. Now, no means we in a court with the man with Onye. The court sets a different date. So Baba Bishia to come and assess what we call punitive damages. Punitive damages means say assessment, was it of an aggravated nature? maybe an abroad so the panel or they could do the benefit or they could do another bisa. Court no a bar as a case or bar as a security damages. The jury now so the court asked the jury says on this you are to assess punitive damages. The jury now says that the OCA now on the Friday now last Friday he has said actual damages at $10 million, compensatory damage at $5 million, and punitive damages at $8 million. Meaning now one about $18 million. And then the defense counsel Adyapong raised the issue that this is grounds for mistrial because instruction of court with the jury it appears that Omojuma is open for Yampono, Oman Tiaswe. Now, if you listen to the video now circulating now, the judge in acknowledging the verdict of the jury indicated that he was going to and before that he had mentioned that he will not take oral submission for mistrial. He will say offer for submission if you are the one who can. If you also are when the judge feels that the matters are weak here, a better choice say come on the record. You have to come with a written submission or written motion.